We can actually solve stuff if we argue about things, when we get to the argument.
Without dismissing them for their identity or their political affiliation or using ad hominem or, logical
fix stuff.
Freedom of speech.
Fundamental rights.
Freedom of conscience.
Academic freedom.
Freedom of press.
And the right to listen.
You're listening to So to Speak, the Free Speech Podcast, brought to you by FIRE, the Foundation for Individual Rights and Expression.
This past weekend, I got a memory on Facebook that it was 5 years ago this week, I think, that Coddling of the American Mind came out. And we had recorded a podcast about that. And there was a picture from the podcast, and we were in our old office on North Capitol, which gave me some nostalgia. But 5 years later, you have another book coming out, Canceling the American Mind. It's coming out when? October
17th.
October 17th.
Me and Ricky Schlott, 20-something wunderkind, and forward by John Haidt.
What's the origin story of this?
Well, it's actually kind of funny. Ricky reached out to me and John because she dropped out of school, college, out of NYU in 2020. When COVID started, which I think was exactly what everyone should have done. Like the idea of going to school during the lockdown just seemed to miss the whole point. But she read Coddling the American Mind, thought it was completely correct, and she wanted to interview me about the idea that maybe COVID itself would present the kind of challenge that would give kids kind of the sense of self-efficacy that we argue that they don't actually have, that at least ones with helicopter parents aren't giving their kids. Mm-hmm. So there was an idea that kind of like COVID could potentially uncoddle kids. Now, she says that ended up not really working out.
Yeah, I was going to say, did that work out?
I'm a little bit more kind of like, we probably don't hear about the ones who actually rose to the challenge and were able to.
Yeah, and I'm sure it's different in every family.
Yeah. So originally, she started writing for Reason magazine, she started writing for the New York Post and a couple other places, and it was clear that she was just this exceptionally clear thinker and writer, particularly not even just for her age, for anyone's age. So she became a FIRE fellow, and we were talking about actually doing a follow-up to Coddling the American Mind together, which, having a Gen Z young woman, made so much sense because so much of coddling is about, problems suffered by Gen Z young women. So, with two Gen Xers, me and Haidt, writing about it, probably wouldn't be as persuasive as actually having someone who...
And John has another book project ongoing, so that's why he's not involved, although he's writing the foreword for the book.
He did write the foreword, yeah. And so we were talking about writing this follow-up to coddling, but then I was watching all these people still trying to claim that cancel culture didn't exist or nothing happened or it's a hoax. And it's like, okay, given I define cancel culture as I have a very simple definition of it, which is just an uptick on people, either being threatened with or losing their jobs or being expelled or tenured professors being fired, that really started to accelerate around 2014 and really went completely off the rails in 2017 and after, and 2020 and 2021, just completely nuts. The idea that there are still people saying that nothing actually happened was something like, no, that's part one, we have to address that. And to be clear, we talk about threats from the right and the left, but the idea that nothing happened in the last 5 to 8 years is completely insane. So that was goal one. Goal two of it was to actually talk about this idea of rhetorical fortresses that I think they have both on the right and the left, which is to sort of situate cancel culture as being part of a way to win arguments without winning arguments, is the way we put it in the book. Mm-hmm. That essentially, if you're having an ongoing debate about a hot button issue, you can persuade and you can marshal facts and you can, have a discussion, or you can make that person terrified that to disagree will actually cost them their job. And guess which way is faster and easier in the age of Twitter? So we try to talk about, about this as a larger, lousy way of arguing. And then the bottom third is talking about ways to get out of this trap that we're in. And we talk about ways corporations can stay out of the culture war. We talk about reforms potentially for higher ed, K through 12, et cetera. Mm-hmm. So we do
much like coddling at the end of that book.
Yeah, but in coddling we spent just a little bit of time talking about reforms, whereas a good third of the book in this case is directed at reforms.
Yeah, with cancel culture, so it was very much a part of the public conversation there for a couple of years. I think 2020 might have been the peak, 2021. Do you think it's waning a little bit? Do you think because you have seen this counter narrative that is pushing back against cancel culture in a way that you didn't really see, aside from the Harper's letter and some things like that. It seems like the normies, so to speak, recognize what cancel culture is and are more skeptical of it than they were, say, in 2019, 2020, 2021.
I feel like I'm hearing a lot of cancel culture being over, but a lot of times it seems to be from kind of the same people who said cancel culture didn't happen in the first place. So it's kind of like, cancel culture didn't happen, and by the way, it's over. It's like, okay, choose one. But for those who do actually believe something weird happened and something troubling happened, I do think that there is some common sense pushing back at the moment. But I'm not going to believe we're in the clear until actually, the 190 professors that we talk about in the book start getting their jobs back. Some of these punishments are, and I think that's something like 700, 600 punishments of professors. The best data we have is actually on professors. When we start seeing better results from students saying whether or not they're afraid to talk to their friends or their professors. And I think that at every stage, and there is some hope on this one, the presidents who, there was 13 presidents who signed a letter saying that they're going to commit to freedom of speech. But the proof, needs to be in the pudding. And right now, I feel like at every stage, and this is an argument we make in the book, from K through 12 on up, there are what I call conformity-inducing mechanisms. You need to actually change that to non-conformity encouraging mechanisms. If you really want to pursue truth, if you really want better ideas and innovation, and that has to start on day one in orientation, that has to start in K through 12. So the idea, I think that people are saying cancel culture is over. I've kind of likened that to the British saying that they won the Revolutionary War because by 1785 the Americans stopped fighting. It's like, yes, because you lost.
Yeah.
So I think speech is sufficiently chilled that you don't have to burn all the witches. Enough to scare people.
Campus free speech, because you've done it for what, over 20 years at this point?
22 years on October 2nd.
Yeah, I've done it for over 11.
Newbie.
Yeah, right. Can be a polarizing issue, but I don't think it's as polarizing as cancel culture, and whether it actually exists. So when you did Coddling of the American Mind, you worked campus free speech issues into this kind of broader narrative and this investigatory story about what's happening to young people. This book more squarely focuses on cancel culture. Do you think the reviews for this book are going to be as across the board positive as they were for Coddling?
No.
There was like one bad review for Coddling from The Guardian, which was maybe a little predictable.
Yeah.
But this one...
Well, the Guardian just seemed to be trying to argue that we were soft right, basically that and essentially like bad people liked us, so therefore we had to be bad too. And that's actually we actually addressed that review.
Pamela had a name for it, right?
The
moral pollution.
Moral pollution. That essentially being close to somebody basically made you evil. So we addressed that a little bit in the book. Now, we really meant the subtitle Coddling the American Mind, how
good intentions
and bad ideas, are setting up a generation for failure. Because we really do think that a lot of what we're talking about in Coddling was parenting, trying to be good parents, and K through 12 trying to be good, but just with some bad ideas. Cancel culture, there's no way to address it and pretend that people who go after, who chase people down on their houses, who issue death and rape threats to their children are good of heart. So like this is one where in order to address it honestly, I feel like you almost are bound to write a more polarizing book because people who actually make the argument that the cancelers had the best of intentions, I'm sorry, no, they were going after their enemies by any means necessary, and that is not something I find commendable.
Yeah.
Do you find that this idea that cancel culture isn't happening or didn't happen of a piece with this, relatively, it's probably not a relatively recent phenomenon, the relatively current phenomenon of, alternative facts?
Mm-hmm. I've noticed that generally the cancel culture doesn't exist, came from people who came at the issue with the fact that it couldn't possibly exist because it doesn't actually agree with my politics and then work backwards. I watch people who literally know nothing about this topic, just being like, oh, it's just a hoax. I'm like, you literally don't know anything about what's been going on campus for the past couple of years. I don't know how seriously I should take it. I do think it is actually, no, it's a good question. Because I think that one of the reasons why we ended up in this situation is, and here it's going to get a little boring.
Greg forgot to turn his phone off.
I forgot
He's
to turn
new.
my phone
You're going to have to get
off.
better at remembering that with all the podcasts you're going to be doing.
So yeah, I was giving the very exciting. It's just about to get boring. Exactly. In law school, I did 6 credits on studying censorship during the Tudor dynasty because I wanted to get at some of our ideas where our ideas of prior restraint come from. And people usually, most people associate prior restraint with the Stuart dynasty, but actually, I realize most people don't have opinions on prior restraint. But those of us who do. And this is a debate that I feel like I sometimes even have with my co-author to a degree, is that anytime you introduce a huge number of people into a conversation, it changes the dynamics. And so the printing press was the best example of millions of people being added to a global conversation. And what was the result? Eventually, flourishing of knowledge and scientific revolution and all these kind of amazingly positive things. But in the short run, an increase in the witch trials, religious war like crazy, massive bloodshed for about 2 centuries. So it's going to be disruptive. And we just introduced 1 billion or more additional people into direct communication with each other through social media. And you really started seeing it hit around 2011 in the Arab Spring. And then it really started hitting campuses around 2014 really hard. Mm-hmm. So basically, my point is that when you have that many new eyes on any problem, it can tear down any idea, any person, or any institution. So the person, of course, tearing down any person is cancel culture. Tearing down any idea is misinformation, disinformation, false facts kind of thing. So I think that there's a lot of effort to have big state solutions to sort of putting the genie back in the bottle. And my answer to that is that's exactly what Henry VIII tried, man. You can't put the genie back in the bottle here. Basically you have to learn to live with the existence of this new technology, and it's going to be difficult, but it requires profound cultural shifts in order to take the best advantage of it. But there's no way this is not an anarchical period.
Yeah, and it's
That was an awesome segue to Texas and Arkansas.
Yeah, I think we're going to get to Texas and Arkansas later in the podcast, but it made me think about the recent FAQ we put out about artificial intelligence, and how futile that one letter written by, I think, Elon Musk and a couple of other tech entrepreneurs was, where they called for putting a pause on AI research and development for the next 6 months while they figure out how to put guardrails around it. I'm in a dynamic global capitalist society, nobody's going to just, where there's money to be made, of course, just stop working on it.
Let's just, because people are so naive about laws sometimes. It's kind of so you do understand that all you're saying with this is just the law-abiding people will stop researching it, and meanwhile, everybody who's completely unscrupulous can go as fast as they want. And meanwhile, the only real protection we're going to have against AI is better AI defenses that come from AI.
Yeah.
Well, it's always interesting when those who are in a market dominant position say things like, well, let's have a pause on this until I figure out what we should do about it and how we should go forward.
Let's have a pause on this until Meta is really successful and everybody wants to be in the metaverse.
That's right.
Sorry.
Well, let's move to some more old school media, backpack patches.
Oh yeah.
There was this issue that went viral, I guess everywhere, not just Twitter, this past week or two, where a student, Jaden Rodriguez, a kid who often has patches and other signage on his backpack. He's in elementary school, I think.
I think junior high, maybe.
Maybe junior high?
Somewhere in that.
I couldn't tell from the
bridge
video.
years, yeah,
in those bridge years. But he would go to school with this Gadsden flag on his backpack. And
remind people which one the Gadsden flag is.
I was just about to because I know some people forget it. But it's the "Don't Tread on Me" yellow flag.
I got the Gadsden flag and the Gadsden Purchase confused.
Is there a Gadsden Purchase?
Yeah, it was a little part between Texas and Mexico.
Oh. Well, the more you know.
Yeah.
But the Gadsden flag comes from the Revolutionary War. It's the yellow flag that says "Don't tread on me."
Don't tread on snack.
Yeah, it's supposed to symbolize the 13 colonies kind of all banding together, and their tail rattles. They all rattle together, I guess, like a rattlesnake. And the school, however, there was a teacher, I guess, who complained about this particular patch. and complained on multiple times. And I guess the student, Jaden, was pulled out of class multiple times for this patch. And ultimately, the school said you can't wear it because the school district argued in this case it had origins with slavery and the slave trade, which is historically inaccurate. I think there are some groups that are maybe far right or right wing that have appropriated the "Don't Tread on Me" flag, much like groups appropriate all sorts of kind of symbols. Yeah, the cross, for example. And maybe they're associating it with that, but its origins were very much with the Revolutionary War and didn't have anything really to do with slavery and the slave trade. So they banned the student from wearing that on his backpack. Echoes, right, of the Tinker case from the 1960s, Ronnie?
Well, yeah, and actually it's funny, there are two patches involved here.
Yes, there are.
Right, so first of all, he'd been wearing patches on his backpack for years without incident, years. And he shows up this year with his backpack and he's got these two patches. One of them is the Gadsden flag patch, but the first one was not "Don't Tread on Me." It was "Don't Tell on Me." It was basically like the junior high school or elementary school adapted version of the Gadsden flag. So
that's hysterical.
Yeah, and the other one was I think FPC Firearms.
It was Firearms Policy Coalition official member.
Right. So it's a patch with a gun and then the name of the organization around it. Standard Second Amendment rights type stuff.
Yeah.
And so a teacher complains. It didn't cause any disruption in the classroom. No one, the teacher looks at it, is unhappy with it. And so there's a school policy that is basically you can't wear anything with guns or sex or drugs or, just kind of this bright line.
Alcohol, weapons.
Or alcohol, weapons, right. And then there's this other, issue of, the Gadsden flag is, somehow racist or something and, counterfactual historically. And they tell him, you can't wear this. And this is, it's funny. We're going to talk about a number of things where my reaction to a lot of it is, my time machine worked. Because here we are, 50 odd years later from Tinker, and we're arguing about what a student can, wear quietly to school to make a political point and what rights they have. And I thought we had settled this, right? And by the way, Mary Beth Tinker, I think, was the youngest of the three. I think she was 14, so she's not that much older than Jaden is here. Yeah. And, I thought the court was very clear in saying that, unless there's substantial disruption or a reasonable forecast of substantial disruption, students can, make political statements through what they wear silently throughout the school day. And, we wrote a letter explaining that, no, the First Amendment, protects his right to do this. There's no basis for a prediction of substantial disruption. There was no disruption. And the thing is, they relented ultimately on the Gadsden flag patch. That, okay, he can wear it so long as nobody complains.
Yeah, would that count as substantial disruption, though, under the Tinker stand-up?
No, actually, there's been case law, even recent case law, where a handful of emails, calls from parents, administrators having to spend a little bit of time on something, that doesn't count as substantial disruption.
Yeah, the 10th Circuit case.
Yes, and more to the point, it's a heckler's veto. By saying you can do something until somebody complains about your speech, well, that's the definition of a heckler's veto.
As long as these bottle throwers aren't mad at you.
That's right. And so that patch, as far as we know, is back on the backpack. Jaden's back in school. But the FPC patch is simply outright prohibited under the policy. And it's hard to understand how the policy is constitutional. It's easy to understand how it's unconstitutional. Yeah. Because you couldn't even wear a DARE patch or a patch arguing for gun safety. Yeah. If there's a gun, it doesn't matter what the message is. It's out, and it's so grossly overbroad, and it affords just unfettered, what they call unfettered discretion on the school. And this is a perfect example, right? Is that you have a teacher deciding without consulting with anybody else, saying, oh, those patches are no good. Ultimately, the administration gets involved and backs the teacher. But all it takes is one teacher saying, this hits me the wrong way. You got to get out, or you got to stop bringing these things to school. And that's not the way this is supposed to work.
We might have to remind the youngins what DARE stood for.
Or
is it just Dare to Keep Kids Off Drugs?
Yeah, Dare to Keep Kids Off Drugs. It was an acronym.
Yeah, it is an acronym.
And you can see how effective it was, because that was from my day. And
Drugs
I have no
are
idea.
really
evil? I don't know.
Oh, yeah.
Maybe. I'm guessing. I doubt that's right. That's how effective the program was.
Yeah.
But you couldn't wear an anti-drug patch. You couldn't wear an anti-gun patch. and there's no reason to think that any of this would cause any disruption or is likely to cause a disruption. The school board and the district are kind of just going beyond what the Constitution allows.
Well, it looks like there's a federal appellate court that also says that a T-shirt with the logo of a gun rights group that included an image of a handgun was materially indistinguishable from the black armbands worn in Tinker to protest the Vietnam War and upheld the student's right to wear that.
Can we complain about bong hits for Jesus?
Go right ahead.
Well, and so that's the interesting part of it is so you see in the policy that they're trying to do their best to include the categories that the court has said, right?
Yeah.
So we know from Bethel if it's kind of indecent or lewd or sexually tinged, whatever, that's categorically something you probably get at. And we know from Bong Hits for Jesus that drug-related stuff, they can kind of, and this is silly, but these are
such a mess of a case.
Right. I mean, it's silly, but these are the rules. But the rest of these categories have never been adjudicated to be something that a school can, and some of them go to the core political speech, such as firearms, right? I mean, and so the policy is unconstitutional. I'm just waiting for the first person to complain. Because all anyone has to do is read the paper, and if you don't want Jaden to be able to bring his Don't Tread on Me patch to school, all you have to do is call up and complain. Now, we said you could wear it until someone complains. Now, on the upside, Superman has come to his aid, I read in an article today.
Which one?
Dean Cain.
Oh, Dean, that one.
That one. Right?
Jared Polis, the governor of Colorado, also came to his defense, saying the Gadsden flag is a proud symbol of the American Revolution and an iconic warning to Britain or any government not to violate the liberties of Americans. So it was nice to see that. As you mentioned, the school district did kind of back down on the Gadsden flag, albeit saying that until someone complains, he can wear it. But they have not yet backed down on the gun patch. Yeah, the FPC patch. So we have a letter out to the school, and hopefully they respond to that. I want to move now to California, where there is another issue that captured attention. This is at Yolo County. In Yolo County.
Really YOLO? Really?
We had to double check that. Yeah.
You
Really
only
Yolo
live
County.
once.
But there was a group, Moms for Liberty chapter, that was hosting some sort of conference at the library in Yolo County, and it was focusing on women's sports and transgender women participating in women's sports, and the organizers were opposed to transgender women participating in women's sports, referred to transgender women as biological men or men. Library manager warned them not to do this because they said that
It was illegal.
Yeah, it was illegal that
Their argument was under California anti-discrimination law, you can't say those words.
Yes. So you had the library's manager sitting in the back, just kind of waiting for them to say biological men or men and referring to transgender women. Gave them a warning the first time they did it. I think one speaker was asked to leave, but they kept doing it, obviously, because it comports with their ideological beliefs about this controversial issue of public concern. And the meeting ended up getting shut down.
Why am I being asked to leave?
Because you were talking about misgender, you were talking about men and female sports.
So
Minutes in.
Minutes in.
I mean, it was supposed to be like an hour and a half, hour 15 minutes, somewhere in that range. And I mean, within 5 minutes, I mean, they pulled the plug.
Yeah. So and this was all captured on video. And the library manager said, if you're speaking about a transgender female, they need to be referred to as female. Transgender male needs to be referred to as male. And if there's any misgendering, if it's by any of the organizers, they will be asked to leave. There are no exceptions. And then one of the speakers, Sophia Laurie, referred to the physiological advantage of male athletes. These comments led one audience member to ask, are you going to continue misgendering people throughout the event? One person recommended referring to them as biological men, and then the library manager shut down the event.
And this is why when people say cancel culture is over, it's kind of like when we've reached the point that you can't refer to biological men as biological men, and where someone's actually gone so far as to believe that it's actually illegal to use that term in the entire state of California, like that means we've been sufficiently chilled in our speech that we actually believe there are massive exceptions to freedom of speech that we all just have to respect now. So yeah, this was about as bad of a case as I've seen.
Yeah, it makes. Go ahead.
And
Ronnie.
bear in mind, they're not referring in the course of these conversations that are on the video to a particular biological male or biological female or transgender male. They're talking conceptually, right? And even then, you can't use the label of your choice based on your perspective or your viewpoint. I mean, there's no complainant per se, except other than the group of biological females who want to participate in men's sports or vice versa. I mean, no operation of a law like California's law or harassment laws generally operate in that way, right? They don't say, just generally to refer to a group as you're talking about them conceptually can run afoul. It's got to be directed towards specific individuals or a group. I mean, like actual individuals or specific members of who make up a group. I don't know what this librarian was thinking, and I have to say it's a little unfortunate that this happened at a library because we've got so many issues going on with libraries right now with books and whatnot. I mean, this could have just as easily been a classroom at the local high school after school where they let groups come in and use it. It could have been a community center. The fact that it's a library, I think, also helps confuse the issues a little bit. The fact that Moms for Liberty, who's also involved in some of the other library stuff, happens to be involved in this, kind of muddies the water. But it's very straightforward. The library opened a forum, groups are allowed to come in and use it. It doesn't matter whether you want to call it a designated forum or a limited forum. It's some kind of forum, and in no forum can government actors discriminate on the basis of viewpoint. It's that simple.
Greg, this makes me think a little bit of your perfect rhetorical fortress, which you referenced at the top of the podcast. So you think about this issue, right? Transgender women in sports. It's so controversial that even the language you use in talking about it signals how you think about it, right? As the library manager referred to here, is referring to them as anything but women, transgender women.
It sounds like you couldn't even refer to them as trans women.
No, that quote I took.
You had to.
Yeah, you had to, right? And then on the other side, you have people saying...
Oh, but it sounds like you just have to refer to them as women, not even
from
trans
the quote.
Women.
He said, if you're speaking about a transgender female, they need to be referred to as female. So you have this hot button issue that if you're on the other side of it from this library manager, you need to adopt the library manager's terms of the debate, the kind of perspective in which the library manager sees the world. Otherwise, in this case, you have your event shut down. And you can see this from the right too by saying, they say you need to refer to them as men or biological men, otherwise you're engaged, you've adopted the gender ideology of the left. So there's you can't win on either sides, and they can push you out of the debate just by policing how you frame it. Right?
So just to go over it real quick, in the book, in the middle part of the book, we talk about cheap dodges to debate. And first we talk about what we call the obstacle course, which are like standard minimization, logical fallacies that can disrupt a speech, that can disrupt an argument, that exists largely to run out the clock in a world of limited time. Most of debates on Twitter, for example, which go nowhere, are primarily just until the other person leaves in frustration. Then the next stage that we call the minefield are the sort of ad hominem attacks that both sides use, and that's like calling someone a grifter, calling accusations of bad faith, minimization, all this kind of stuff that everybody uses.
So we have this fortress in the center, and these are the walls, or the minefield, so to speak, that go around it.
And we talk about the efficient rhetorical fortress on the right, which is, you don't have to listen to liberals, experts, journalists, and if you're really hard right, anybody who disagrees with Trump. So we call it efficient because there's only 4 levels. But meanwhile, since so much of the norms around speech policing have come from campus, I call the one on the left the perfect rhetorical fortress, because it's just layer after layer of ways to get out of arguments. And a big part of it is, one, of course, you can dismiss anybody that you can deem conservative. That doesn't mean they are conservative, by the way. That just means you just have to allege it. And
it doesn't fire, know it.
That derails the discussion. And I call that out as the first step. But then we go through the demographic funnel, which is everything from your race to your gender identity. And we worked out that gets you down to about 0.4% of the population of the United States. But then
that you can't dismiss just out of hand.
Yeah, that you could figure out a way to run down the clock by bringing this up, or otherwise dismiss. But there's a wonderful kind of turn at the end, which is like, oh, but by the way, if you have the wrong argument, you still don't count. You could be in that 0.4%, but you will actually be hated even more if you have the wrong argument. Which points out that this is primarily to protect dogma. I mean, Coleman Hughes has this incredible quote that we quote in the book. He's a black contrarian, who absolutely brilliant 20-something. And he talked about how I keep on being told that being black is key to my being taken seriously on issues, any number of policy issues. But then when I have an opinion that doesn't actually, match what they think it should be, I'm suddenly told I'm not black. And I asked every black conservative that I knew, and a lot of black moderates, including people like John McWhorter, like, have they been accused of not really being black for their opinions? Every single one of them was like, oh yeah. And I'm like, okay, so this is about protecting dogma. It's not actually about what you've convinced yourself about, that it's about just protecting the marginalized.
I think that's one of the kind of concepts that you have in your book that I hope at least will catch on, because I think it's a perfect way of encapsulating how debate and argumentation has evolved in our society. Yeah. Just these barriers. Devolved, yes. Had these barriers to actually getting to the argument itself and the substance.
We can actually solve stuff if we argue about things, when we get to the argument.
Without dismissing them for their identity or their political affiliation, or using ad hominem or logical
we can fix stuff.
Yeah. So this is a case we also wrote a letter on, and I think both of them will result in lawsuits. We'll see. I don't think we've seen any lawsuits yet on either case.
Not yet.
But I want to turn now to a case where I think we did just see a lawsuit recently. This is the Marion County newspaper case.
Oh yeah.
So this is a case involving the Marion County
Good
Record.
old-fashioned case.
Yeah. The Marion County Record in Kansas. It's a small local newspaper. The city had its entire 5-officer police force and 2 sheriff deputies go into the paper's offices and seize everything.
Yeah.
But also the house of the 90-year-old woman who was the part owner of the paper as well, they went in and seized everything.
And according to her son, who I think also worked for the paper, she died the next day, he thought, in part due to the stress caused by this. A little bit of background here, right? So the raid, reading from the Kansas Reflector here, the raid followed news stories about a restaurant owner who kicked reporters out of a meeting with U.S. Representative Jake LaTurner, and revelations about the restaurant owner's lack of a driver's license and conviction for drunken driving. I believe the restaurant owner is starting a business or a catering enterprise and was trying to get a liquor license or something else for that. And so there was this concern about this record and driving without a license that the newspaper was tipped off to. And so the newspaper tried to corroborate some of these facts. I guess used allegedly a public database to look into it. Then was concerned that some of the information was gathered illegally or something. So they went to the police and told them about this.
And by the way, they didn't publish.
And they didn't publish any story related to this. Fast forward, their offices get raided. Ronnie, why is this wrong?
Where to begin?
What do you mean? These are brilliant police tactics. Why is it wrong? Because the government doesn't get to go in and seize the tools of publication just because they think that you have published or are thinking about publishing something that they don't like. I mean, we have in addition to the First Amendment, we have a whole federal statute that prevents this. We had the federal statute, the Privacy Protection Act, that grew out of the raid on the Stanford Daily, where unless the actual crime is being committed by the journalist or the publication and the evidence is, on the premises, you have to use a subpoena to get materials out of, the press, the offices of the press, the property of the press. And, there was a warrant sworn out on probable cause to authorize this. Let's call it what it is. It's a raid, right? Yeah. To authorize this raid. Later, it was labeled improvidently issued. You think?
That's an understatement.
Yeah, and the newspaper is, and you know, this is a small newspaper in Kansas, but the entire press nationally got up in arms over this, as well they should. There is a lawsuit that has been filed.
I think by one of the reporters.
By one of the reporters. And I think also, I need to double check this, but I think the editor of the paper as well. I mean, someone can sue on behalf of the paper.
I'm sure if it hasn't been filed, it will be soon.
Yeah, I mean... And I mean, I don't know if have you seen the video from the mother's house. Mm-hmm. There's video of the cops in the mother's house. They're taking apart her computer, and I will give the police at least enough credit of the, you know, they were very kind and they were explaining what they were doing and that they had a warrant and, you know, they would say, come over here and whatever. But she's yelling at them, you know, you have no right to do this and that's my property, and she's absolutely right. And she dies the next day.
God, yeah, it's just such an awful case.
It's just such a terrible
late 90s. I forget.
Yeah, she was 98.
98. Yeah.
And and I think they did the raid like on a Friday afternoon or something like that. They tried to do it in a way that would get minimal coverage, and it's like, well, good luck with that.
Yeah.
This is insane.
So the allegation here is that when the Marion Record was looking into this restaurant owner's driving history, they were suspected of relying on information, personal information that they shouldn't have had. That was.
I'm only laughing because the justification was so thin.
Yeah, I mean, it was. There was suspicion that the source for the information was the restaurant owner's husband or ex-husband who had filed for a divorce, and you know, all of this kind of messiness surrounding it led the paper to not publish the story and to report it to the police.
And it's important that you note that it wasn't a matter of the newspaper going out and, you know, accessing unlawfully information, which, by the way, wouldn't change the right for the police to raid, but it makes it even more clear-cut because we know from Pentagon Papers and from Bartnicki versus Vopper that the fact that the press receives information that might have been unlawfully gained by somebody else who gave it to the press, it doesn't in any way, shape, or form diminish the right of free speech and the right of free press of the newspaper or whatever type of publication it happens to be. I mean, this is black letter law.
Yeah, it's the Pentagon Papers.
The Kansas Press Association has kind of a fundraiser open for the paper with T-shirts and coffee mugs and hoodies emblazoned. So the paper actually ran, I think, on its normal schedule. They managed to do it without any of their assets, and Fire actually placed an ad, or a couple of ads. Two ads, yeah. But the headline on that first issue after the raid was "Seized but not silenced," and so you can go to the Kansas Press Association's website. It's a fundraiser for the paper, and get T-shirts that say "Seized but not silenced." I bought one yesterday and 2 coffee mugs. We're going to put them up here in the office. So if you're looking to support them, that's one way to do it. There is also kind of an allegation, or a suspicion, I should say, that the police might have been inclined to raid this newspaper because the police chief, new police chief, I believe, Gideon Cody, was being investigated by the newspaper. And maybe the police chief got wind of that, was concerned about it. Those are some suspicions that are going around. I don't know anything about it. But
meet the Streisand effect.
Yes. So we've seen one lawsuit there from a reporter. I did read, Ronnie, though. You know, they might have been polite on that video, but there was one reporter who alleged that the police snatched their phone from their hand or something like that, out of their hand.
In the press office.
Oh, in the press.
I don't think that happened.
There were a couple of raids.
Yeah,
right.
So there's the raid at the newspaper's offices.
Yeah.
And they were not quite, I mean, at least from what I could see on the video, it didn't seem like they were. I mean, it didn't seem like they were like going in, you know, guns drawn and, you know, jackboots and whatever else. But it didn't seem like they were exercising the same care that they tried to exercise at the mother's house. Mm-hmm. But yeah, I mean, there was. Bottom line, they should not have been there in either place.
So next I want to turn to a slew of court decisions that came down late last week.
Texas three-peat?
Yeah, there was, I think it was Texas was slapped. Texas was slapped down thrice, I think is what we used on Twitter. And Tyler helps with our social media stuff, is behind the camera, and might have had something to do with that copy. But there was 3 kind of censorial laws in Texas that were slapped down, and then one in Arkansas. So I want to move through them with you guys and get your perspective on them, because they all deal with issues that are kind of recent trends in the First Amendment world, although issues, albeit that have been addressed by courts in the past, but they just keep cropping up, right?
Yeah, every now and then the attorneys for the state, whether it's Texas or elsewhere, will just kind of have a bad week. Like, for example, the last week of the Supreme Court term, Colorado, poor AG, had a particularly bad week with counterman being decided against the state and with 303 creative being decided against the state. Last week it was Texas's turn, where they had, like you say, 3 decisions decided against them.
And I think the Texas Attorney General, Ken Paxton, is up for impeachment this week. I think
he
his
sure
trial in the Senate starts today.
Right. As a matter of fact, if you look at one of the cases is the Free Speech Coalition's challenge to the age requirements for online adult content.
Well, let's start there. What is that, Ronnie?
So, basically, and this again is another one of these cases where I feel like, oh, my time machine worked, because we're right back where we were in 1997. I mean, when the Telecom Act of '96 was passed, they adopted first it was the Communications Decency Act, the provision that didn't survive, the provision that we all know and love now, Section 230, that protects third-party content on online platforms.
Well, let's educate the youngs a little bit about that. That's one of the reasons why I went to law school, and it literally was a ban on indecency on the internet, which was
Isn't
adorable.
that the definition of the internet?
Well, as with every technology, the leading edge tends to be adult content. I mean, that's why
Wasn't that the case with credit cards too? That it was
credit cards.
There was a movie made about it.
Betamax.
Yeah.
Virtual reality.
Virtual reality. I mean, it's that's where the money's going to be.
Hopefully that's
where
not the case with robots too.
Pornovation.
I don't know how to tell you this, but anyway, so the federal law basically said, like you said, it basically tried to outlaw indecency on the internet, and the way it did it was, it said if you had content that would be inappropriate for minors to access, you had to check an ID and so on and so forth, and the Supreme Court came out and said, no, this is fully protected speech. If you're going to, in any way really impede access by adults, it's going to be unconstitutional. It has to satisfy strict scrutiny, and that means
ACLU v. Reno.
Yeah, and that means you have to use the least restrictive means. And the court was very clear. You haven't, and this is early in the internet, right? You haven't tried filtering. You haven't tried doing stuff at the ISP level. You haven't tried a bunch of other alternatives. This can't be the least restricted. And I'm grossly oversimplifying ACLU v. Reno and the follow-on case FSC versus Ashcroft, because Congress tried again. This is essentially the same statute.
Well, but there's something that I think makes it decidedly worse, though. This is the one that had the warning labels.
I haven't even gotten to that part.
Yeah. That's compelled speech, which is the heart of darkness when it comes. Which is it's worse to tell people what they must say than what they can't say.
So this is kind of a two-parter. Let's talk about age verification first, because I think this is something that, on its face, a lot of listeners will think, oh, age verification to access pornographic sites on the internet makes sense, right? Mm-hmm. But there are some serious First Amendment and privacy concerns that if you are going to implement age verification on this, it will also apply to adults, right? Because they need to provide their information to prove that they are above age, which is different than showing your driver's license or some other sort of identification at a video retailer or at a newsstand, right? Where you're just kind of flashing it. No data is actually transmitted or submitted electronically. Online, it's a little bit different, right?
Well, yeah, and bear in mind also that those ID checks, whether it's walking into a strip club or buying certain magazines or renting certain videos, those are not government-imposed requirements. I mean, they are.
I think a lot of people will be surprised by that. They're voluntary?
Yeah, I mean, what you basically have is you have laws that say it's unlawful to provide to minors material that would be obscene as to minors. Yeah. And material that's obscene as to minors means, by definition, that it's not obscene full stop. Obscene full stop, you can regulate for everybody, adults and minors. Obscene as to minors is content that is protected as to adults, but it's not appropriate for minors because it satisfies a modified version of the test for obscenity that is directed towards minors. And so in order to avoid inadvertently selling a material that might ultimately be deemed obscene to minors to a minor, a retailer, a purveyor will check an ID. A strip club, if they're serving alcohol, is going to check an ID because you got to be 21 to go into a place where there's alcohol. I mean, that's a separate category. But like you say, online, in order to do this, you're basically asking everybody who wants to access this content, and it's a very, very broad definition of sexual content. And it's a fairly broad definition of which websites and services.
I think they need to have at least a third of their content be indecent or obscene as to minors, or
sexually explicit, or whatever it is. Yes. And when you think about it, that's not a lot. And you basically are creating a record under a government law announcing that I'm going to go watch porn online, and that's not comfortable for some people. And as a result, they're not going to go watch porn online. So you're creating a very significant barrier to access to protected content online by having these age verification laws. And by the way, they're not terribly effective, because if anyone knows how to use technological tools to get around, for example, what happens is, and this is an example in Virginia, and I checked because Virginia has a law also, and I'm a member of the First Amendment Lawyers Association. The lawyers who are bringing these cases against these laws around the country in Utah and Texas and other places are members as well. And they passed a law in Virginia. If you go to an adult website in Virginia and you want to see the content, there's an age gate. Please, demonstrate that you're over the age of 18, and you have to upload an ID and every, whatever else. I could ask my kids, and my kids are, late teenagers. It's not like I'm asking little tiny kids to help me, access the porn. But I could ask my kids, and they'd be able to tell me, not that I didn't know myself, how to use a VPN to mask your geographic location. So now the website doesn't know I'm in Virginia anymore. Yeah. I'm in. It's that simple. And so also, the law can only cover entities that the state has jurisdiction over. So all these foreign websites that may be available in the state that the state can't get to because they're outside the United States, they're not going to be, age verifying their users. So the law isn't having its intended consequence, but it is having the consequence of making people who don't know how to use a VPN and who do want to access it but don't want to create a government record. Now, the laws do, come up with this framework of a third-party intermediary where you show your ID to the third-party intermediary. The intermediary, informs the website that you're allowed to go forward, and ostensibly that. But even so,
and then it's supposed to delete.
It's supposed to delete it. But as the court says very clearly, there are data breaches. There are even innocent mistakes of things not being deleted. And it is a significant burden on the right of adults to access protected information. And then the court very carefully goes through, is this the least restrictive means? It's still strict scrutiny. It's still a content-based regulation. And lo and behold, just like in 1997, and again in the early 2000s, when the Ashcroft case was up in the Supreme Court and bouncing back and forth to the Third Circuit, the court said, no, there's filtering. You could, for example, have ISPs. And I'm not necessarily advocating this as a constitutional solution in of itself, but it is a less restrictive means. You could, at the ISP level, tell subscribers that if you want to be able to access this material, you'd have to, affirmatively turn on the access to it. Mm-hmm. But, no one would have a record of that. You would simply make that choice yourself. That is putting the power in the hands of the parent of individual children to make decisions at the device level or at the access point level whether or not they want to allow access, not having the government come in over the top and create rules for everyone, including adults who have full rights to access this stuff.
One of the things that was interesting about this law is that while these third-party services that these websites could hire to check this data had to delete the data, the government didn't have to delete the data. And one of the two possible mechanisms of a verification is through the government, through your government-issued ID. And the court talks about how Louisiana passed a similar law to this, HB 1181, just shortly before a vendor for its Office of Motor Vehicles was breached by a cyber attack. So these vendors can be hacked as well, right? So and injury occurs, according to the CURT, because the individuals know that information is at risk and that hacks happen. Even at the highest levels of our government, hacks happen. And there are states still, even after Texas sought to criminalize men having sex in the privacy of bed. That law, I guess, is still on the books in Texas. The court says here, given Texas' ongoing criminalization of homosexual intercourse, it is apparent that people who wish to view homosexual material online will be profoundly chilled from doing so if they must first affirmatively identify themselves to the state. So there's a chilling effect, kind of the big brother's eye.
How is that still around? That's
well,
Lawrence v. Texas.
Well, because what happens oftentimes is a law will get declared unconstitutional and it's invalidated, and the technical way it works is there's an injunction against enforcement by the state attorney general, whoever has the enforcement power, and in order to comply with the injunction, they simply can't enforce it. Very rarely, I think, relatively speaking, does the state actually go back and scrub the offending statute from the code. Sometimes they do. I mean, often, in fact, they tend to do it if there's some other separate reason that they're going back and revisiting that chapter or that part of the code. But if they don't, there's still. Because
that would have to happen legislatively.
That's right. That's right. It means that they have to pass you have to go through a whole legislative process, pass a bill amending the law to repeal it or to amend it to something constitutional. And, unless there's a reason to be there, most state legislatures don't bother. I mean, even the provisions of the CDA that got struck down and left Section 230 to protect the third-party online speech, those provisions are still in Title 47. They're just sitting there right next to 230. You just can't be enforced.
So what this boils down to is that there are less restrictive means available. Content filtering, allowing people to manage this content at the ISP level and opt in if they would like, and also that there are these larger privacy concerns by having to submit your personally identifying information to either a third party or using government tools to do so. And none of this, as you mentioned, Ronnie, is new. These cases made their way in the 90s. There is an argument that the technology has gotten better since then, but as the court clearly lays out here, it doesn't fix the strict scrutiny problem, and it doesn't necessarily fix the new technology doesn't necessarily fix the privacy problem either.
And the state has the burden on all of these elements of the test, including the burden of showing that the potential less restrictive means are in fact not effective. And there's none of that here. There's no findings. There's no, legislative history or hearings demonstrating. I mean, they have. It's funny because I don't want to jump ahead to the Arkansas case because I want to talk about the disclosures in Texas. But they have an expert that's, supporting these statutes, and it's the same expert in Arkansas as in Texas. And you see both courts basically rejecting the experts' views on the efficacy of these alternative means, among other things. But do you have the language of the disclosures by any chance in front of you? You can read them.
As part of this law in Texas, this age verification law, there's also mandatory disclosures, and we're litigating a sort of issue like this, which is actually cited by the court in this case in New York regarding their hate speech law in Volek v. James, I think is the title of that case. But they have mandatory disclosures here. It says, Texas Health and Human Services warning, pornography is potentially biologically addictive, is proven to harm human brain development, desensitizes brain reward circuits, increases conditioned responses, and weakens brain function. There are two more that kind of track that.
No, you have to read them.
All right, we'll keep going.
They're sufficiently ridiculous that they should be read into the record.
Texas Health and Human Services, this is the second one. Human Services warning, exposure to this content is associated with low self-esteem and body images, eating disorders, impaired brain development, and other emotional and mental illnesses. Texas Health and Human Services warning, pornography increases the demand for prostitution, child exploitation, and child pornography. So porn sites would be compelled to put these on their websites, much like, I guess, cigarette manufacturers are forced to put a health warning on packages of cigarettes. The funny thing is, though, that the Texas Health and Human Services has never actually itself issued these warnings
or made
come to these findings.
Or made these findings.
Yeah, or made these findings.
I'm shocked that they stopped short of blindness and hairy palms. I mean, it's
And I guess the expert in this case even admitted that these claims are controversial and non-settled.
Right. And so the law in this area is...
To say weak evidence would be an understatement.
Yeah. The law in this area is, it's compelled speech, right, which is anathema. I mean, it's to make somebody say something, even a company. It's just not what, the First Amendment anticipates the government doing. And there's a very narrow exception to that rule. I mean, for example, you can't compel someone to recite the Pledge of Allegiance in elementary school, in public school, right? We have Barnett. You can't compel someone to put "Live Free or Die" on their license plate if that's not something they believe in. You can't force people to include in their parades groups that they don't necessarily have an affiliation or in philosophical agreement with. We don't compel speech. The narrow exception is commercial disclosures.
Yeah. So is this like the California, according to the knowledge of the state of California, this product, causes cancer, or the cigarette warning labels?
Yeah, that's Prop 65, and that has its own problems. We could do a whole separate podcast on Prop 65 cases. But more broadly, the seminal case is Zauderer in the Supreme Court. And basically the test is the government may impose disclosure requirements where commercial speech is or might be misleading. Mm-hmm. And the requirements are that the disclosure has to be purely factual, non-controversial, and it has to be no more burdensome than necessary in order to solve the potential misleading problem. And originally, this rule applied only in the commercial speech context. Over the last 10 years or so, we've had an issue with what I call Zauderer creep, where the government, having found that they were getting slapped down in court more frequently when they tried to prohibit speech about a product or service, or about anything for that matter that they thought the public should know the truth about, they would start imposing disclosure obligations instead. So, for example, there's a federal agency that wanted to compel disclosures about companies' use of certain minerals that were conflict minerals in their products. And again, that's kind of a very controversial issue. What does it mean to be a conflict issue, a conflict mineral, right? It comes from a country that doesn't have the best practices, whatever it is. And the court ultimately struck that down. And one of the classic examples is, the packaging and advertising for tobacco products. And, even there, where that's commercial speech, when the government tried to require graphic warnings, disgusting pictures like brown lungs.
Which you see in Europe.
Yeah, which you see in many other countries, including Canada. The court stepped in and said, look, this isn't purely factual, non-controversial. And by the way, the tobacco companies didn't challenge the new warnings about cancer and low birth weight and everything else. What they objected to were the pictures. But I mean, the insurance companies tend to have relationships with like windshield repair. Like one of the things that's covered in many car insurance policies without paying the deductible is when you get a crack in your windshield, because they don't want to spread and have to pay for a whole windshield. But they're often affiliated with specific companies that do the work, and so the insurance companies will refer to the affiliated company. And some states have these requirements saying you must tell the customer that there are other alternatives out there, and you must identify some of them. And some of these regulations have started to, stand. And the D.C. Circuit, among others, has backed away from the requirement that this applies only in purely commercial speech. That is, speech that proposes a commercial transaction. The court in Texas strikes down these disclosure requirements for the adult content websites for a variety of reasons, not least of which is it's not commercial speech. Texas tries to argue that, these websites, they're out there and they're accessible because they want people to buy subscriptions, or they want them to buy the content. And so there's content that's available for free, ergo it's advertising. The court bats that away and says, no, that's not proposing a commercial transaction. You're talking about the actual speech. And then when they get to the purely factual and non-controversial part, I mean, these are laughably not even close to being purely factual, non-controversial. And as you said, I mean, there's actually no findings. I mean,
From the Texas Human Services.
The disclosures themselves are misleading by suggesting that the Texas agency has in fact made these findings and that they are in fact valid.
Yeah. Mm-hmm. We should move quickly now because I realize we're over an hour and we haven't covered all of the cases. So we'll get through them quickly just so our listeners are familiar with them. Of a piece with this age verification law in Texas is a law in Arkansas, Ronnie, which you reference, that requires a parental okay or permission to create social media accounts. These are kind of proliferating across the country. Greg, I know you've done a lot of research into kind of the effects of social media on certain demographic groups, but as a First Amendment matter, what does the First Amendment say about limiting young people's, minors' access to social media?
Well, it's many of the same problems that the Texas law has with respect to sexually explicit content, right? You've got the same problem of age verification. How do you do age verification without having the same privacy problems that you have, and therefore creating impediments to adults who, are, free to use social media, services. And the court in Arkansas also steps through much this very similar analysis, even though it's talking about social media as compared to adult content.
Yeah, and the thing is, kids have free First Amendment rights.
Yeah,
and certainly that the government's often found to have a more compelling state interest the younger the kids get. But certainly, there's no question that particularly teenagers, have pretty relatively strong First Amendment rights, and you can't just kind of bat that away. And if people, and I am persuaded that some social media is quite harmful for some young people, but that's something you have to prove to go for as sweeping as a state solution as saying that no kids can be on social media whatsoever without parental permission. That basically says that actually we changed our mind. Teenagers actually have no First Amendment rights, which would be a distressing and inappropriate change in the law.
Yeah, some of these laws, although I think they've gotten better at it, don't distinguish between young minors and older teenagers, right? I think Arkansas, Ronnie, and correct me if I'm wrong, kids 13 or under were blocked from access to it completely, or maybe under 13. Older kids needed parental permission, up until the age of 18 in order to access these sites. A lot of the case law stemming from this comes from Brown v. Entertainment Merchants Association, which involved a California law that banned the sale of video games or violent video games to anyone under the age of 18, not distinguishing between a 17-year-old and a 10-year-old, for example. This one did distinguish between a 12-year-old and a 17-year-old, but it still restricted access to it. And separate from that, the Supreme Court has only held that these regulations as it pertains to content of minors apply in contexts where material is sexually explicit, right?
That's right.
They've never gotten to violent video games or the potential psychological harms of social media. They might one day, but as of right now, that sort of delineation between adults and minors can only occur in the sexual content.
That's right. I mean, one of the points that the court made in the violent video game case, EMA versus Brown, was that we have only ever said that material that's obscene as to minors may be restricted as to minors. And by the way, one of the features of the case law that allows that restriction is that parents are still permitted to give the material to minors if they so choose, whereas the California law made it, impossible for minors to purchase this stuff. And I don't believe that there was any
accounts,
but the video game law was struck down for a variety of reasons, not least of which was, well, what does it mean to be violent, and how does this differ from? There's lots of and Justice Scalia's decision goes through all kinds of violent content that has been available through the ages. Beowulf, for example,
my favorite comic books.
Right. I mean, all of that stuff, and so you're right. You can't kind of bat away. But what's interesting is you watch how this kind of creeps along. So we start with, the COPPA, Children's Online Privacy Protection Act. This is a statute in among the FTC statutes. It says you can't collect or disclose information from collected online from children under 13 without verifiable parental consent. Okay, and that there's a whole framework around that. By the way, never constitutionally challenged. You know, no one wanted to be the poster child for that. We don't know whether that law is constitutional or not. There are arguments on both sides. And then you've got, years go by, and now you have the California Privacy Act, which now imposes restrictions on the collection and use and storage of information on minors under the age of 18. And they have separate rules for the group that's older than 13 and separate rules for the group that's younger than 13. And now we get to Arkansas social media restrictions. And like you say, they've got one set of rules for minors who are 13 and over, another set of rules for those who are under 13. And by the way, the social media companies, the big major ones, they all disclaim having availability to minors under 13. If you look at their terms of service, they say point blank. And, because they are not services directed toward children, they are not obligated to comply with COPPA unless they get actual knowledge that a specific user is under 13. But they started doing that from the jump because COPPA already existed. But you can see the creep, how you let these incremental changes go unchallenged. And next thing you know, you're looking at a social media law like this in Arkansas, and you're like, how did we get here? And you bring the constitutional challenge and it succeeds. Well, it's got to go up on appeal yet, so let's see what happens. And the same thing is true of the Texas case. Let's see what the Fifth Circuit does with it.
Yeah, one important point I think worth making is that parents have the means to police their kids' access to social media. And as we've heard from social media companies, parents just voluntarily decide not to use it. The record in this case shows that they're fairly easy to use. There was no dispute by the defendants that it wasn't easy for parents to use this content and filtering mechanisms that prevent their kids from accessing social media or pornography for that matter, any content on the internet. It's just parents, much to the chagrin of many social media companies, aren't utilizing this. And as we learned in the Playboy case, right, if these sort of voluntary measures that could be taken by parents are met with, to use the court's phrase, a collective yawn, it doesn't mean that the government gets to step in and violate the First Amendment, or at least First Amendment principles, and play parent for parents who decide that it's not worth doing it in the first place. And I think that should be a compelling argument for libertarians, civil libertarians, anyone who believes in parental rights, that parents should have control, and they have the tools that the social media companies have created to prevent their kids from accessing this sort of content online. They just choose not to use it. And when you're talking about young kids, you're talking about them being at school, at home. If you give them a device, that's a device you give them unless they are somehow independently wealthy and can go purchase it. Before you give them that device, set up the parental controls on it. But parents just aren't utilizing those tools. And so the government, assuming in these cases, just assumes it's their responsibility then to be.
And that's why I was talking about the need for cultural shifts to adopt to technology. And I do think that, like the stuff that I learned from writing Coddling the American Mind means I have all sorts of, like my kids don't know how to use a tablet. And I see kids who are, using the screens from interactive screens since they're three and up.
Yeah.
And I do think that some of this stuff, there are going to be more parents taking advantage of the stuff, because it's not like there are no parents who take advantage of some of these technologies to, keep their kids off of social media, for example, or porn. We haven't fully adapted to the reality of this,
Yeah,
and the by record. The way, one less restrictive means that rarely gets mentioned: teaching technological literacy. We don't teach that in school. You have mandatory, sex education in most schools. You can opt out as a parent if you want, but ask kids what they're taught about how to interact with the online world and where to place credence and what dangers are out there. You get some of the apocryphal things where your parents tell you, the child molesters are out there on the internet, don't do this and that. But we're not really teaching them in any meaningful, structured way. Here are some ways to interact with, whether it's social media or even being an online shopper for that matter. You're going to see products where it looks too good to be true. And, if you look at the URL and you click behind it, you're going to see that it's not really who they say they are. We need to teach kids as they start, like you say, if they start using screens at the age of 3 or the age of 5 or the age of 8, whatever it happens to be, coming along with that should be understanding what that environment is. Just like we teach them when we allow them to start walking a few blocks to the park or whatever it is, we teach them about stop signs and crosswalks, and the same thing should be happening. And that's a less restrictive mean than the government coming in and bigfooting over who uses social media.
Not just educating kids. I think
Well,
the case
sure, but-
talks about it, but like educating, the government hasn't put any money toward educating parents about these voluntary content filtering tools that the social media companies or, any technological provider, computers or, operating systems on phones provide to prevent access to this. And the court goes to great lengths to say, this would be a least restrictive means that has never even been pursued. So why don't we start there first? We have two more cases, but I think we're just going to talk about one. There was a federal judge in Texas. I'll just give the listeners an update on this. I want to talk about the book rating system, which is just kind of weird and novel and unique. But first, there was also a judge in Texas, I think it was a federal court, it was a district judge, who struck down a drag show ban in that state, which is of a piece with a number of other courts striking down drag bans in states like Tennessee, for example. We're litigating a case at West Texas A&M where a college president banned a drag show on that campus for very weird reasons. You got to read the letter that the president wrote about his reason for doing those. But I want to very quickly discuss, separate from that case, is the federal judge who barred Texas from enforcing its book ratings law. And this was a law, HB 900, that would require school library vendors. So these are book publishers, right, who sell their books, or companies that take books that are published by publishers and sell the books to libraries, to rate all of their books and materials for appropriateness before selling them to schools based on the presence of sex depictions or references. It also requires vendors to rank materials previously sold to schools and issue a recall for those that are deemed sexually explicit and are in active use by a school. So this essentially requires book vendors who sell books to schools to go through their entire catalog, not only future, but past, read all the books and determine, under some of the vague standards that Texas outlines here, whether a book is sexually explicit and give it a rating.
Yeah, and I mean, what's interesting here, and listeners need to understand this, is that at every stage, people can consider whether or not a book is age appropriate or age inappropriate, and that goes for bookstores if they want to, public libraries, K through 12 libraries. I mean, that's part of the practice. But requiring booksellers to actually go through and warn people about content by very vague standards, like that, is also compelled speech for one thing. And it's it's going a step way further than they should be allowed to.
Yeah, and it also empowers the Texas Education Agency the authority to review a vendor's rating. And if the TEA disagrees with the vendor's rating and gives it a different one, the vendor must use that rating. And vendors who do not will be added to a list of vendors that can no longer that schools can no longer buy library materials from. This kind of makes me think of kind of comic books and all these sort of rating enterprises that have been proposed in the past but have been never gone anywhere, but are voluntary.
Almost all voluntary.
Almost all voluntarily now.
Right, and the law is very clear. You can't turn a voluntary rating system into a government enforceable scheme. But this goes back even further. I mean, my time machine is working so well. This goes back to the church saying which books could be printed and disseminated, right? I mean, you've got the government saying, go figure out which of these books have...
Or Henry VIII, that comes full circle.
Right. I mean, go tell us which books have sexual content, and we're not going to use those books, and we're going to make you recall any that have already been sold. And by the way, if we don't think you're right about it, we'll decide and we'll make you withdraw those books. I mean, it's like the priest ringing the bell in Cinema Paradiso, right? Every time there was a kiss, you had to ring the bell, and they would take it out so you could show the...
So that's a great movie, by the way.
So that you could show the film in that town. I mean, none of this is new. I mean, people who pass these laws think they've stumbled across a great new idea. You go back and read Jacob's book. Every single evolution of communication beyond one person talking to another one has come with exactly these kinds of, the sky is falling, it's going to be the end of civilization, the government or the church has to step in and say how it can be used. And over and over again, from comic books to television to records. I mean, this is Bob's book in a nutshell, right? And now here we are with the internet and now social media. I'm sure we're going to have the same thing with AI if we don't have it already, and whatever's next. It's just, we've been fortunate every single time that, at least in America, every single time the First Amendment and free speech principles have won out, for the most part. I mean, if you watch TV today, and go back and watch TV when we were much younger, and talk about parents got to watch on TV, the world has changed. I mean, we've been fortunate, but you have to wonder, if we're not careful, the way that the technology develops can be greatly impacted. I mean, if Section 230 had not been put into place, we might have ultimately gotten to the same point. What Section 230 says is that if you run an interactive computer service and you host third-party content, you're not responsible for any liability that arises from the third-party content. You can't be treated as the publisher of that content. And that's what allows comment sections, right? And that's what allows ultimately
uploads to YouTube and
right, and uploads to YouTube, and ultimately all social media, because all social media is nothing but third-party content.
Yep.
If Section 230 hadn't existed, I have often envisioned an alternate history where we kind of get to the same point just under the First Amendment. Because you remember there's old cases about how you don't.
What's the matter? Is topical?
Yeah, sorry. So there's been some miscommunication. I have a Twitter space that I need to start. Can I just keep?
Yeah. Which button do I press?
The big red button at the top.
Okay.
I apologize, guys.
Okay.
Sorry.
Our videographer needs to go do a Twitter space.
I apologize.
We talked too long.
Yeah, so I envision an alternate history where we get there through the First Amendment through doctrines like we don't hold bookstores responsible for selling books that might be libelous to somebody. I mean, the liability goes to the author or the publisher. It doesn't go to the bookstore. I think we'd ultimately have gotten there, but would the internet have had the rapid growth that it experienced, and would there have been a critical mass of utility that drove investment if 230 hadn't been there?
No.
And by the same principles, if you're going to start stepping in on social media or you're going to start stepping in on AI as it's coming around the bend now, you got to be very careful, not just to not infringe speech, because of course that's the whole game, but also be careful even about if you can overcome those hurdles, putting them there, because it can actually alter the way the technology and the market develops.
Yeah. The interesting thing about this is, as Greg kind of mentioned at the top of this discussion about this case, is librarians have to determine age appropriateness for the books in the first place. So what the state is essentially doing here is offloading it to booksellers and then forcing them to do this very burdensome activity retroactively, and they might come to determinations that are different than librarians, and you have different age-appropriate considerations depending on what sort of student that library serves, whether it's an elementary school student or a middle school student or a high school student. So, and that's all that is separate from how vague and overbroad this particular law is in determining what is.
Well, and in that respect, it's depictions or descriptions of sexual conduct or sexual activity, however they define it, which means that Catcher in the Rye.
Yeah.
Out, right? I mean, and Beloved. I mean, it's not just the books that always show up on the banned book list. I mean, if you think about, arguably, any discussion about sex, no matter how non-sexy, no matter how non-prurient it is, no matter how innocuous or instructive, if it's in there, it comes out. Which, by the way, makes me wonder how they have sex ed in Texas with a textbook these days, because by definition, wouldn't that qualify?
Well, yeah, you could still have the sex ed book. You just have to have a rating on it, presumably. So, But anyway, guys, we went way over time, and we lost our videographer who had to go do some Twitter space. I really appreciate it. Greg Lukianoff, of course, the president and CEO.
Sign up for my Substack.
Foundation for Individual Rights and Expression, also coming out with his book in October with Ricky Schlott, which you should pre-order. It's available for pre-order now. And of course, Ronnie London, our general counsel here at FIRE. I thank you both for this.
Sign up for my OnlyFans. No. Kidding.
What a note to end on. Thank you, gentlemen.